last lecture that I need 12 of you to be paying attention while the rest of you do whatever you're going to. Decide amongst yourselves between each lecture, because again, this is pass-fail. And attendance is fundatory or mandatory, depending on how you choose to view it. Realize that you're getting ever closer towards the end of this semester, and this is one of those periods where we're actually going to apply some practical learning. Hopefully you get something out of that. Hopefully if you got a question about what you're about to get into, or for the rest of your professional career, we can get you an answer to those things. Today's kind of a fun one, talking about a word that's just fun to say and you're going to be stuck with it for the rest of your life. I'm still Colonel Douglas in spite of my best efforts, and we'll move forward. Well, maybe if I plug it in, that will be 100% smarter than the equipment. All right. Any questions from last class? Does anyone remember the last class?
Yeah,
I'm still Colonel Douglas. All right. Yeah. Thanks. A plus for you and a pass fail. It's amazing.
It was one of the better TED Talks I've listened to, sir.
All right. And I named Ted, and I feel great about myself now. All right. So remember last time we talked about the difference between criminal and civil law. We'll talk way too much about the Constitution, all my conspiracy theories. Over the next 6 other lectures that we give, you'll reveal more of the conspiracy theories that define Colonel Douglas's nature. But just in a revisit, coffee! For any of you that have been in the military for more than a minute, that last part feels incredibly familiar, right? All right. Let's get back to the lecture. But we talked about the distinction between crime and civil, and one of the things I brought out of that last lecture was the fact that in the military, there's a lot of distinction that because you are in the military, the administrative rules, the administrative processes of them can turn something that would otherwise be civil for you as a U.S. citizen actually into a crime. So today we're going to spend most of our time talking about the civil matters that relate back to the profession of medicine. So get back into this one, y'all. And of course, it wouldn't be a class if we didn't have objectives. We're going to talk about the 3 elements of tort law, the difference between intentional, negligent torts, and in fact, the next lecture, so class 3 that we'll get into next week, we'll talk a lot about negligence, talk about some defenses in liability, and then we're going to talk about informed decision making, so informed consent and informed refusal. Most of you, since you put on a uniform, have not had the ability to inform or refuse anything. There is one specific period in the past 5 years where informed refusal had a major national consequence, right? That COVID-19 thing and the vaccination component to it, right? And we're experiencing the counterswing to that as well. And frankly, if you're going to be a provider in a period where national public health is, going to be provided, you're going to be a part of that equation, whether you think about it or not right now. So torts. What is a tort? Right? I put a Pop-Tart up there because when I think of tort, I think of tart, and a Pop-Tart is a crime against humanity, and therefore a tort also is a crime against humanity. Also, for those of you who have, who have been negligent in your home front on getting like the gingerbread house or make the cookies or whatever else for the holiday season, and you got little ones, or you have other people that have little ones, go buy some Pop-Tarts and some icing, and you can make all of the Pop-Tart, gingerbread houses that you need to. It's an arts and crafts thing. You just stay the hell away from whatever's going on and offer some, constructive criticism as an architect, when it's all done, and then eat the remains. But holidays are coming, folks. A tort, it's non-contractual. Why is it non-contractual? What has to exist for a contract to occur? 2 consenting parties, right? One who's delivering something and one who's agreeing to receive something. So a tort, by its very nature, cannot be contractual. And it's a civil wrong, meaning that in the determination of the court is only going to measure the issue of whether or not one party harmed another, right? Does that mean it can't be a crime? Can a tort also be a crime? Right? A tort can be related to a crime, but the tort itself isn't the crime. There's a specific crime terminology that would be applied, but the tort itself would be the damage or the harm that's related, okay? So it's a civil remedy to compensate victims. The principle of the tort and why it constitutes almost all of major civil law, and why you see it in the mornings when you're watching the morning news, called the Fours, Thomas J. Henry, and apparently if you're good with torts, you get helicopters. It's the liability for harmful consequences, regardless of whether they were intentional or not, right? That proposes a sense of justice in your soul, that if somebody keys your car, they're probably responsible for repairing the damage, right? There's some other thing that they're probably responsible for, like finding a new dentist for the teeth they ought to be missing. But beyond that, the idea that if you damage something intentionally or unintentionally, that there should be some compensation to make the thing whole again, right? Now, in the space of intentional torts, intentional tort really makes a different assessment of the tort itself, because it gets into the mind of the individual that's performing the action, right? I decided that I wanted to harm this individual. I made a declaration of harm for this individual, and therefore I conducted it, right? Negligence is the opposite of that, right? So I've got a teenage daughter. She gets asked to babysit in the neighborhood, right? What if she stops paying attention because her phone is very, as a 17-year-old, your phone is pretty much your lifeline to your existence, right? What if for half an hour, she's paying more attention to her phone than the 2-year-old who is choking on Jell-O or whatever else, and maybe first choking on Jell-O is really shameful, right? Those parents should be ashamed of their kid. But equally important to my daughter's existence as a babysitter, did she intend for that kid to choke? No, absolutely not, right? The claim of an intentional tort against the babysitter is a very difficult one to make, right? Because a babysitter's negligence can be very, very high, but the actual intent that's related to the damage is, less likely. Even if she didn't like the kid, it's not likely that she was stuffing Jell-O down the kid's throat, right? Which gets into the criminal side of assault and battery. And then strict liability. So anyone own a dog? Right? You own a dog. If your dog bites somebody, is the dog liable for the action, accountable for the action, or are you as the owner liable for the action, regardless of the circumstances that are there? That's the best example that you can get to with strict liability. If you are the owner of the animal and you're managing it in such a way that it can cause harm to another person, strict liability means that you are considered at fault, regardless of the fact that you didn't actually cause the damage itself. Another agent did, the dog in this case. Your liability is one that takes the place of the animal, and same thing for defective automobiles, right? So before most of you were born, when the Ford Explorer was an actual SUV and not whatever it is right now, was a bougie sedan on stilts. They had a partnership with Firestone. Firestone made all of the tires for the Ford Explorer, and about 1 in every 700 tires for Firestone had a faulty weld defect in it. That doesn't sound like that big of a number, but 1 in 700, and they were making about 1.2 million Ford Explorers. And they were putting these tires that within the first month of selling them, the vehicle, all of these cars were coming back and saying, my tires are blowing out. What was Ford's liability at the point that the first set of customers came back is negligence, right? They didn't have proof that the tire was going to explode under pressure. After they started receiving claims at multiple dealerships for tire replacement on brand new vehicles, what did they have? They had a strict liability to address the problem and fix it. If you've had a car or a vehicle that's got a manufacturer's defect notification, they tell you to come into the dealership to get it fixed at no cost to you. That's an example of how big strict liability can be in terms of torts, right? Some intentional torts, the ones that you've heard of, right? Assault. So if I run up and screaming at you, and I'm being loud and I'm being obnoxious, and you're afraid for your life, even though I don't make contact with you, that's considered an assault, right? A fear of unwanted Assault has just been consummated by what? Battery, right? So, no matter how slight the touching occurred, this gets into the realm of what you as a medical practitioner need to be very conscious and aware of, is that your patient cultural norms, your patient's expectation of authority or allowance for authority, the age, the religious or other construct of the patient may play into what they believe constitutes an assault or a potential battery, right? So this is where most of us are working to try to avoid, again, any litigious responsibility. Assault and battery are really the two places where we as medical practitioners run into some problems. So if you're in the Army and you're going to go to a battalion aid station where you're going to do a whole lot of different things to prepare for deployment, thankfully we're protected from a lot of these components. But if you are on the civilian sector attempting to apply medical care the same way, assault and battery would be considerations for a lot of the different practices that we engage in. We have some special protections, again, from the federal system, and we'll get into that in a few slides. False imprisonment. So somebody goes to the emergency department and they're having an emergency and it's taking too long for them to be seen, or they're being impatient, or they don't like what is going on or what the next step is. Hey, we need to admit you so that we can send you to surgery to take care of this problem. Your appendix has got to come out tonight. You'll probably die if we let you go. Can the hospital make the decision of its own accord to force that individual to come into the hospital? They can't, right? If they did, right, and this is a flexible change in the sense of authority within our nation over the past 50 years. So about 60 years ago, if the hospital decided that it was the best decision for you and your care, the hospital lawyer could make an easy determination of incompetence for you. They'd place an order with a magistrate or a judge, and they could say, no, we can admit you for care because you're out of your right mind. Right? That has gone far out of the way because thankfully with the rise in insurance doesn't want to pay unless it must pay, right? And they use the notion of autonomy here to say this would be a false imprisonment, right? Patient has a right, and that's why we get into the right to refuse and right to consent. Defamation. Untrue statement purported as fact has to be published, right? Not on your mother-in-law's blog or whatever else like that, unless it's read by millions of viewers, right? It's got to be a publicly made aware claim that it is untrue. Now, when we talk about defamation, and you represent the United States government, you represent the Army, the Navy, the Air Force, the Coast Guard, whatever else like that. You represent your unit's practice, and somebody makes a claim that they have been unfairly treated by your unit. Can you protect against defamation for your unit? Does the federal government have a right to protection from defamation? Does a unit have a right to protection? We talk about tort. A tort is a harm to a person, or it's harm to a agency that is private in general, right? So you can't make a claim of defamation against the Coast Guard, the Army, the Navy, the Air Force, Space Force, whatever, in that sense. If you're wearing a uniform, though, there are a whole lot of other things if you're making a false accusation against your service, right? And so that's where, again, federal rules get into play. Intentional infliction of emotional distress and outrage are two unique components, right? So mental anguish. I'm suing you for mental anguish. I observed the trauma, and now I'm upset about it. Now I have PTSD, and now I'm seeking counseling, right? So 3 different levels: mild, moderate, and severe emotional distress. So emotional distress, you had to have been party to the events around the injury, right? You had to be present when the badness was happening. Outrage is the continuation of concern following somebody else's exposure to that, right? So they're in the same family. One of them is directly exposed and the other one is the consequences of exposure. And then wrongful death, where you're civilly liable for the death, and we'll show one here real quick sec. Now, intentional torts, by virtue of establishing that intent was present, can be a crime. Anyone heard of O.J. Simpson? All right. The criminal case went out a couple of years before the civil case. What did the criminal case find? Mistrial, right? We couldn't convict the individual of the crime because the proof to a jury in the criminal case was much higher than the burden of proof in a civil case, right? So there are certainly areas where a crime can also be committed at the same time that a civil matter is being adjudicated in summary judgment by a court. Yeah, what about this guy? Eric Birdman, right? And you know you love it. Okay, it's okay to admit it, right? So Alec Baldwin, what did he do? Shot two people, same bullet. Wow, it's actually kind of impressive considering the fact that
It's a great shot.
you know, it's an unfortunate accident, right? It's an accident that occurred in a movie where there were some previous complaints about the armorer on set and the assistant director, that they had been negligent on previous films working together, and that on the day of the shooting, apparently one of the armorer's ammunition suppliers brought new ammunition to the set, and somebody mysteriously loaded a revolver with a live round. That the actor, in rehearsing, apparently pulled the trigger and shot the whatever she was a camera operator, I think. Shot the camera operator through the chest, and then it lodged in one of the other director's shoulder, right? So one fatality on scene, and the other person evacuated to Santa Fe Hospital for several weeks for him to recover from being shot in the shoulder. Smells like a crime, right? You shoot somebody in the United States, that's probably a crime, right? You killed somebody. Did he mean to kill somebody? It's really hard to establish that, right? Even if he was saying the lines, like, I'm gonna kill you, and then pulled the trigger, pointing it at the camera, and it ended up killing somebody, is that acting? Is that not acting, right? Did a damage occur, though? Probably so, right? At least one dead person and one person went to a hospital. So clearly damages are in play. The criminal outcome for the person who pulled the trigger, though, was dismissed. Why? Because the prosecution withheld evidence that would make an effective defense for Alec Baldwin, right? So it's a violation of the rules of evidence. The judge dismissed that trial with prejudice against the Santa Fe District Attorney. The armorer tampered with the weapon and tampered with the ammunition, which complicated her ability to mount any kind of defense because she was responsible for the weapons and ammunition on the site, right? So it's an involuntary manslaughter. 18 months of prison. 18 months of prison for somebody shot in the face, shot in the chest. Another person nearly shot in the face. 18 months in prison for that. Mostly because she tampered with the evidence, otherwise she may have just been given probation. The assistant director, who was responsible for bringing the armorer in spite of all of the known complaints about it and ignoring the complaints that were brought up by the cast members. Negligent use of a deadly weapon for allowing a deadly weapon to be on a scene where Alec Baldwin was holding it and pulling the trigger, right? So what are some civil concerns that you think about in this one? Who's going to have emotional distress? Eric Bergman, right? Yeah. I mean, yeah, he's going to have emotional distress, but he's also the producer of the film. He's the one who shot somebody. Does he have a right to sue the victims for the emotional distress of them dying in front of him? That sounds like, I mean, it does sound a little funny, right? But isn't that interesting case law? This is why we don't like lawyers, right? Because it is an interesting case law. Yeah, can I sue the people that I shot because their deaths caused me harm? Right? Yeah, potentially, but probably not. It's not going to work out. It's going to get dismissed, right? But the deceased, she no longer has the capacity to sue, but she's married, right? Does her husband have a loss of marital consort at minimum, right? He's going to deal with the consequences of his wife died on the scene, and it was because of Eric Wellwood. Right? What about the director who took the bullet wound to the shoulder, and now he's never going to function the same way ever again? And the movie didn't make a lot of money, right? So how's he going to be compensated for this thing? Here's an interesting one. The medic who wasn't expecting to be called to the scene for a gunshot wound, because that shouldn't happen in a movie, was there for protection of falls and otherwise blunt trauma, not expecting a penetrating trauma kind of injury, not prepared for a penetrating trauma injury on scene, who spends 30 minutes attempting to revive somebody who's non-revivable on scene while calling for EMS. That's a pretty serious outrage, right? You're going to deal with that for the rest of your life, that you were not prepared. You were the medical advisor on station and not prepared for that, right? You wouldn't have even thought about it because, no, these movies are safe. No one ever gets shot making a movie. Right? Other than this, there's probably 2 or 3 other times in modern history where somebody, okay, Bruce Lee's kid, but that was like 1983, right? It's fairly rare and spectacular when that happens. Administrative penalties, right? So this gets into the statutory and the federal side of it. So we know that clearly there are a whole bunch of lawsuits that spring out of this towards Alec Baldwin, away from Alec Baldwin, towards the producers of the film, the directors of the film, to the film agency, to the ranch where it was being filmed on, because there is some vicarious liability of the space by not having everything set up for emergency care when it was necessary, right? So there's a whole litany of lawsuits, and the majority of those have either been settled privately or they've been reduced or removed by a judge saying, no, this is unnecessary, and you can't demonstrate any of the qualifications of the tort. Intent, no, you can't say that anything here was intentional. You can absolutely claim negligence, but the negligent parties have been arrested, and essentially their financial worth is relatively low compared to what everybody who's attempted to make a claim against them. So you're not going to get much out of them. So you could win in court, but you can't get anything out of somebody. Is it worth taking it to court? Right? That's a discussion on the civil side. Administrative penalties, though, gets back to the statutory responsibility, again, in the state of New Mexico. Right? So if you shoot somebody while you're making a film that is covered by Occupational Safety and Health Bureau of New Mexico, you're violating a principle of a safe and healthy work environment, you can be fined, so an administrative fine. It's an interesting piece that a $140,000 fine is levied against the producers at the site. And what does that $140,000 generally go back into? The criminal costs of conducting the investigations, right? Because the police don't get to charge you a fee for conducting investigations. The EMS service responding to it can charge the victims fees for flights to hospitals paid for by insurance. But the only way for the state of New Mexico to compensate for the amount of incredible investigation and the PR fiasco that's occurring at that time to manage those things is through a recollection through administrative fees. They don't say that's why it's for, but frankly, that's why these administrative fees exist. Okay, so we can see in a couple of circumstances where criminal actions and civil penalties can certainly overlap, and it's getting to the heart of what kind of tort to determine what kind of liability or what kind of proof of injury has occurred for us to make a successful tort case. So there are some defenses to intentional torts. First, the elemental response to an intentional tort is that the tort actually didn't happen, right? Somebody accuses you of slapping them and that didn't occur. Well, the elemental component of a tort of battery is that you had to prove that battery occurred. You had to prove that assault occurred. You had to prove that false imprisonment occurred. So that proof relies on the complainant to bring forth enough proof that actually occurred. In the era of videoing everything, cameras everywhere, certainly the elemental defense gets harder and harder if you actually did something. In the state of medical records, if you document something, and this is an important professional foot stomp, if you document that you did something and it turns out that it was wrong dose, wrong site, wrong limb, wrong eyeball, whatever it may be, that you perform that action on, I would highly, highly, highly encourage you to not attempt to go back to that note and correct that note. You would addend that note, you would append that note with an additional note saying that, in fact, I actually performed it on the correct side. But going back into a note that you have already signed and completed after an event occurs fulfills proof of intent when no intent may have existed at the time of treatment, right? And understand that since you control access to documentation of the medical records for the patients that you see, getting back into patient records once they're complete is it's a cautionary tale to avoid doing that wherever possible, okay? Talk about consent. And this one gets unusual, and you'll see, a few of you will see this in your emergency departments, that people come in at late hours with unusual stories and circumstances, and then a social worker will go into that room because somebody's got bruises or something else like that, and they will be trying to question aggressively, one patient or the other or both in separate rooms, what in fact actually happened. And it turns out that in the role-playing event between those two individuals in a moment of passion, right, that something went a little bit too far, but they both have an express or an implied consent to what they were doing, and neither one of them wants to make an issue with it. And you'll spend, because it'll come to you as a urgent care style concern into the ER, right? It'll be somebody that comes in because of some minor thing, and as you're questioning the patient, it becomes clear that there may be something a little bit more to it than that. But in terms of the defense against whether a crime has occurred is when two parties, in intimacy, have agreed that this is what was going to happen. There may still be an emergency that needs to be taken care of, but it may be that no crime or no damage because both sides agreed to it. We may also see this when people are trying to engage in activities to gain an advantage over somebody else, right? So somebody wants to get out of school. They want to get out of school, and they get somebody else wants to get out of school, and they get somebody to hit them, right? There's consent in both ways. They're not gonna go fight later on, but they both got out of school because they got suspended for 2 days or 4 days, right? There's a whole lot of different conditions where we see in the tort side that consent is one that has to be determined. Did you agree to that harm? This is the principal defense also of medical malpractice, that the patient was knowing and aware of what was coming to them and they agreed to it, right? And we'll get into that when we talk about enforcement. Statute of limitations. Statute of limitations, anyone heard of a guy named Bill Cosby? Right? What was Bill Cosby's principal defense for all of his civil lawsuits? He won all of them initially. Happened a long time ago. Makes sense, right? You're bringing a civil case against somebody for something that happened 40 years ago. Do you have a clear memory? Can you prove intent? Well, in his case, yeah. I mean, the claim pretty much relies on intent. But when the cases are brought forward, the statute of limitation has expired. Does anyone recall what pushed that over the edge? It was the volume of complaints with the same story, right? Individuals who did not know other complainants bringing the exact same condition over, and so that resulted in judicial review that says, well, perhaps, in fact, maybe there is something bigger to this, and overturned in 2 states their statute of limitations, or allowed it to be extended because it was the discovery of the consideration of it being a crime. It wasn't the actual conduct of the crime itself, right? So this changes case law, that it's now no longer when the event occurred, it's when the individual realized it was potentially a crime. How does that affect you guys? Hopefully not too much. But if you were a obstetrician in the state of California, you went from having a 2-year liability for the delivery to a 40-year liability about a decade ago, a little over a decade ago. 40 years of liability for a delivery plan. Now, if you can imagine, you were born in the late 1970s or early 1980s on a paper chart record. Imagine what that paper chart record of delivery probably looks like if you're delivering 3 kids a night or 4 kids a night. It's a whole bunch of it looks like fencing on the piece of paper, right? You scribble a few lines. You might put an APGAR score, because APGAR had been invented recently. You guys remember APGAR, right? Okay, grimace, something else, APGAR, right? Yeah. So you might put these things down, but now somebody in their 30s gets arrested for driving while intoxicated. And then they assault their arresting officer. And at their arraignment, they come back in and say, well, it appears that every couple of years you've had a problem. You've had a problem with the law. You don't pay your bill. You don't do a lot of things well. And a creative lawyer looks back and says, well, yeah, look at his birth record. His APGARs were like 5 and 7, and they should have been 9 and 10. Now, do you think there's any real proximate cause between somebody getting pulled over for a DUI and fighting with the cop and a delivery that occurred 38 years ago? Probably not, right? That's a hell of a stretch. But again, the distinction between what we understand as medical professionals and what the common U.S. citizen understands about those things, you could make the argument that, yeah, they've always been in trouble because of low oxygenation following a unusual birth plan, right? And it was documented by the doctor who performed the birth. So perhaps they're liable, right? Truth against defamation. Colonel Douglas is a terrible golfer. How dare you publish that, right? And then we golf, and you're like, no, the truth is in your handicap. It's well above an 18, right? And 18 is the limit for a bad golfer, right? So the truth, is that part that shall set you free. But what do we tend to do when we're accused of something, or when we feel our honor is impugned? Do we tend to under-communicate or over-communicate? Over-communicate, right? That's a cautionary tale for us in terms of defense against a tort, because we might over-communicate the truth in that status, and by over-communicating the truth and our perspective in the truth, we may create a counter to that as well, right? So just understand that the truth is generally the best defense, and that's typically why the federal government doesn't defend itself against accusations that are incorrect or otherwise. We know what the truth is. We're big enough to understand it, and in some cases we create the truth. So, right, we might as well make sure that we're protected well from defamation by saying, yeah, we know the truth. Self-defense, defense of others, right? So the defense against assault and battery, I was defending my family. I was defending myself, right? This is the most common reason why battery charges, occurring after 10 o'clock or 11 o'clock at night, just get dismissed by the judge. It's going to go to a mistrial. The jury's not going to be able to make a clear definition of who was wrong and who was right. And as long as no other harm occurred, it'll be misdemeanor battery charges against one person or another, unless you bring a weapon into it. Right? Self-defense is probably the most common reason, but when I grew up, when I was a little kid, self-defense was a little bit more common as a reason for people to get involved civically. And as we've become a more litigious society, as more civil cases have come up, and frankly, there are just more lawyers around. What are your thoughts on self-defense? Anyone have an opinion on self-defense? Does it feel like it's a safe environment in the United States to engage in self-defense right now? No. Right? I don't think it is either, right? And so what does that give rise to in a Second Amendment country? Concealed weapon carry, open carry, right? I love Texas. Man, I love Texas, right? So we go from a self-defense notion where people were generally doing it with their fists or the objects on their body, and now what's the new object that's being carried by a good number of God-fearing Texans, right? A concealed weapon, right? So does anyone feel comfortable bringing a knife to or your bare knuckles to a gunfight? Like I'm in the small arms category right here, but no, we're not going to do that. Appreciate that self-defense, defense of others occurs quite frequently in this country. And there are more evidences of self-defense where no battery is actually being occurred or it's stopping a crime before it begins that have been documented previously. But that being said, there's also an increase in the number of assault with deadly weapon. Again, not battery, we're not shooting anybody, but assault with deadly weapon because of the rise in weapons, because of this general sense that self-defense requires an escalation, right? Last one is necessity. So you're driving at highway speeds. What are highway speeds on I-10 heading towards El Paso? 85, 97, right? Let's call it 97 because you might be doing 80 or 85, whatever the speed limit says, but the traffic is doing 97 miles an hour, right? And that Firestone tire in your 1992 Ford Explorer gives away, right? Now, somewhere close to Fort Davis and Fort Stockton and places we don't care about in West Texas, there's like 3 miles worth of solar panels out there because that country's only good for solar panels, and that's about it, right? 400 million years ago it was underwater, and since then it's just been useless territory for a few road runners and a lizard, and now solar panels. But your gloriously restored 1992 Ford Explorer on 3 wheels now crashes through about 1.5 miles worth of solar panels owned by Solar Tech Incorporated. And you're now trespassing on private property, right? By diverting off of the highway, you saved the lives of the occupants of your vehicle, you saved the other occupants on the road, the actual harm of you wrecking into them, but you just damaged a whole bunch of property, and now you're 1.5 miles into private property. You've now engaged in destruction of private property, and you are trespassing. Can Solar Tech take any action against you civilly for the intentional tort of you trespassing and you damaging their property? They absolutely can. It's a limited defense for necessity. But the necessity was your choice was either to wreck into other people on the highway or veer into their territory. Necessity, using human harm as the greatest element of concern in our society, you avoided human harm by damaging property, right? So there's a limited liability for how much they can take back to you. Now in the state of Texas, there's a limit to torts anyways, but from this standpoint, when we talk about necessity, protection of others gives way to a defense of sorts against intentional torts. So how does a PA avoid torts? Don't assault anybody, first of all, right? Malpractice is a form of assault, potentially battery, but before you get to battery, you had to have done a really poor job of explaining what you're about to do. You guys were just also conducting battery against one another if you were refusing to do those ultrasound examinations, right? Because you had a contract implied by the person who willfully took off their shirt with their six-pack abs and laid down. For those of you that did, you all had six-pack abs, right? An ultrasound examination on an individual is a perfect example of assault consummated by battery in the medical setting. Diagnostic, right? There's no procedural code, again, for you doing it necessarily. You're doing it for a diagnostic reason. But if you didn't explain to them that you're going to put cold gel and that you're going to disrobe the individual, that you're going to then apply a probe to their skin and you're going to move around in ways for you to see an image that may make them uncomfortable, and you don't need them to write out their consent to it, but they just have to acquiesce to it so you can document it in your record. Cornerstone, again, of medical tort lawsuits. Explain what you're doing before you do it. Provider, you're the expert. You have autonomy to act, which is what defines you as a professional, right? So a professional is defined by autonomy to act. You don't have an algorithm that tells you what to do. You just do what you think is best in the situation. The patient has demonstrated less knowledge. Otherwise, they wouldn't need you, right? Dear God, in the era of AI, we hope that's not the case. But the patient has less knowledge. They are also subject to a permanent change or outcome. Like the ultrasound bill was really cool and reminded me of my childhood, and now I've got emotional distress. 20 million, right? Personal and methodical, transfer information, right? So if you're doing an ultrasound, describing what you're doing because it's not invasive to the patient is probably sufficient. If I'm penetrating your skin for any reason, if I'm taking something off of your skin for any reason, if I'm creating a new hole where no hole were before, then I should have some methodical transfer of information telling you what I am going to do, the express limitations of what I'm going to do, how the patient can identify when I've completed that action, and that they understand it, right? And that proof lies with you because you have the authority and the capacity to document it. Make sense? Right? Your strongest protection against a claim by any patient in any setting, military or otherwise, is by making sure that you control the documentation that begins with a thorough explanation and a check on learning from the individual, okay? That gets us into informed decision making. There's two sides to a coin. Really, there's always two sides to a coin. A three-sided coin would be useless. Informed consent and informed refusal, right? So if I can give informed consent, but I have no authority to refuse, then I'm really not giving you consent. If I can't say no and I can only say yes, I've joined the United States Army, right? Smallpox vaccine. Before you get on there, remember, everyone here got their smallpox vaccine. Hey, don't answer that because I don't need to know your medical history. Anyways, the smallpox vaccination hasn't changed much from the 1700s. Somebody developed the world's smallest, two-pronged trident. Bident? I can't say Biden. A bident, right? They stick it in a slurry and then they start stabbing you in the arm, right? When they've done it about 17 times, they put it away and then they wait for you to have a terrible skin reaction that results in a scar on your arm. Inoculation, it's the best, right? There are some folks that chose to refuse getting the smallpox vaccination going to the global war on terror. Like, no, you read me the vaccine information sheet. This is on a federal exempted approval for you to be administering the smallpox vaccine to me. This isn't given to anybody else in the United States. I don't understand why you're giving it to me. The last documented smallpox case was in 1972. Right? It seems a while ago. You're giving it to me for a risk, but there's also a risk, like the number needed to harm when we go into science on getting a smallpox vaccination is much higher than the number needed to treat because, again, there hasn't been a case since 1972. So using informed consent rules, if I were an American citizen, I would say, well, this is absolutely stupid. No, why would I ever consent to doing this? I refuse. And what happened to the folks who refused while they were at the SRP site? Does anyone remember? Any of you recall? Like, if you refused at the SRP site, then you were sent over to the commander. The commander gave you a direct order. If you refused that, you were sent over to Installation Trial Council, who then asked if you wanted to continue to serve or not. And then you said yes. And then I was waiting for you as a PA before you got on your flight with the smallpox vaccination medic and the documentation thing. And that was before you were supposed to get on your flight. Then we were going to give you your smallpox vaccine, and I was going to have to manage that while we were in Kuwait. Right? That, ergo, is the process. Now, what happens if you refuse the smallpox vaccine at that point? Taking a civil matter, a refusal for care, and now we're turning it into a crime. Why? Because now you're missing movement. Oh my gosh, that federal government system, they get you in the best ways possible, right? So in informed consent in the military, and we'll get to, it's a later slide, informed consent without informed refusal really isn't informed refusal. But let's talk about this from the standpoint of providing care to our beneficiary population. An 18-year-old dependent, so my teenage daughter next year, comes into the ER with right lower quadrant pain, fever, chills, anorexia, vomiting, hallmark symptoms of some condition. Hopefully she's not pregnant. Oh, God, better not. Right? CT scan confirms, after the negative pregnancy test, CT scan confirms, right, that there is a dilated with fat stranding appendix. Classic hallmark appendicitis, right? We knew it clinically before we even got the CT scan, but the CT scan is like icing on the cake. 18-year-old in the ER doesn't want to have a surgery. I don't want 3 holes in my abdomen. That's a terrible idea. No, my belly's too good for this. Like I don't want holes. Is there any other way you can treat this? Well, we can give you antibiotics. That's got about a 60% efficacy. We need to admit you to administer the antibiotics. It's going to potentially keep you in the hospital longer, and if you get worse while you're on the antibiotics, then we may have to override your autonomy and perform the surgery. I don't want the antibiotics then. Why? My job was not to sell you a surgery and endorse the surgery, even though I'm a surgical PA and I love the surgery. It's so easy. It's the best. Like honestly, of the surgeries, the appendix removal, the best. Right? My job isn't to sell you on a surgery. It's the Cadillac of surgeries. It's the best one. My job is to get you the care that you are willing to accept because you have to live with the consequences, right? The 4-ounce weight loss is probably not what she's looking for. You know, there are other organs we can take out that will get you a lot more weight loss if you're looking for that, right? But the issue of informed consent is that I gave you enough information for you to make a reasonably informed decision, and that you demonstrated the competence and awareness of the consequences of not accepting my decision before you gave your informed agreement or your informed refusal. Okay. Legal age. So that can vary with marital status or whether you have had a child or not. And it varies from state to state on what you're allowed to and not allowed to consent to. So a 17-year-old joins the Marine Corps, finishes with training at Camp Pendleton, and is sent up for language training to the Defense Language Institute in Monterey, and has decided at the age of 17 that he never wants to have children. Doesn't want to not have sex, he just doesn't want to have children, right? And so he would like a vasectomy. Seems like a reasonable request for a 17-year-old to make. No? No one agree? I don't see a lot of heads going up and down, right? You understand why he's thinking that way. Like when I was 17, I wanted nothing to do with anybody's children and certainly didn't want to have any of my own, right? But is 17 years of age an appropriate decision for consent in the state of California, where he is unmarried and doesn't have any, other reason why this surgery would be necessary? Now, it's a beautiful thing to note on the sidebar here that because the individual has not completed with all of his initial military qualification, he's not eligible for an elective vasectomy anyways, right? But the end point here is that in the state law component of this, even though we're the federal government, I'm going to have to send him to a California provider in the state of California to complete this whatever action I decide. We're not going to do it in the Presidio Monterey Clinic, right? They tried a couple of cases and realized it was a terrible idea to do it in an outpatient clinic and that it was best performed. So it's going to have to happen in the state of California. So if I'm not aware of my locality's laws and rules, which is that a 17-year-old can't get a vasectomy, and I send a 17-year-old to go get a vasectomy, if the urologist performs the vasectomy, they've committed what? Malpractice, right? They haven't necessarily engaged in the torts in the individual, but they've definitely committed a component of malpractice. Ability to take in information. That makes sense. Ability to process information. That kind of makes sense. Ability to communicate information. So if I tell you something and then I ask you if you understand and you make no movement whatsoever, can I imply consent? Right? Imagine with autism and autism spectrum disorders how hard it is to discern consent for simple procedures, tonsillectomy, right? Somebody with autism wants to get LASIK so they can see better. It's a benign procedure. Anyone here think that LASIK is a really complicated procedure? I wish I could teach you guys how to do it in iPad. Make some money on the side. Not practice. Anyway. I beat that one to death. Decision-making capacity. The information. What do we need to tell a patient that we're going to do? First, what are we going to do, right? If we're talking about a procedure, this is the procedure. Do we get to use the technical term? Right? We're going to do a rhinorrhaphy. Rhinorrhaphy? That sounds like a great word, rhinorrhaphy. Probably a very technical term. I mean, you get to charge more money for every extra R that you put in rhinorrhaphy. Right? We're going to perform a nose job. Well, a nose job gets a little bit closer to what we're talking about. What does a nose job mean? Well, a nose job is generally any surgery about the nose that corrects the bony structure to include refinement of the bony structure to make your air passages more accessible. That's a really good explanation of what's going on. Is it going to hurt? Oh, absolutely. One of the most painful things that will ever be done to you in your entire life. You're welcome, if you agree to it. So we need to provide them information. What in lay person's terms are we actually doing for the individual in such a way that we generally talk about the 4th grade reading level, and not all 4th graders are the same. So just a simple explanation that everybody can kind of repeat back, what did I just tell you that I'm going to do to you? Tell me again what you heard me say is going to happen. And you break it up into segments and chunks so that they understand it, right? So the first thing is, this is what I intend to do. The next piece is, here's what we think it will do, the benefit, right? I want to do this rhinorrhaphy on you because you have total occlusion on the left nary, and which means you can't breathe effectively out of your nose, and when you do, you give your position away for your unit. Why? Because you squeak like a duck. All right? Okay, that seems reasonable. What's the next thing I need to tell them about? So I've told them what the procedure is. I told them what the expected outcome is going to be. I need to tell them about, this word begins with an R. It's a board game. It takes too long. Your uncles used to play it. Risk. All right. Yes, risk. Absolutely. I need to tell you about the risk. Why do I need to tell you about the risk? I'm a very good provider. Good with a chisel. Right? So, go ahead. Informed consent, right? So what if things go poorly? What if you're unhappy with the results? What if I put your nose way up here? Right? It's possible. Right? It's possible that as I'm chiseling, I get a little too aggressive. I get distracted. I have the wrong music on there, and I'm hitting it way harder than I probably need to. Right? And then I'm reconstructing with bone glue and your skin a new and different style of nose that hasn't been seen before. Right? I need to tell you what the risks are. What about infection? Is infection ever a risk when we're talking about a procedure? It's always the number one concern for a reasonable concern. What's the most unreasonable concern about procedures that a PA does? Rhymes with meth. Right? Death, right? So death. Death is always the number one risk when we're talking about informed decision making. Is there a risk of death for doing this? Okay. Liquid nitrogen cryoablation of a mole or skin tag. Do I need to put death, reasonably speaking, do I need to put death on my informed consent for liquid nitrogen ablation of a skin tag? Do I need to put it on there? Has anyone ever died of a mole or skin tag being removed from liquid nitrogen application about the skin? Injury to the epidermal dermal border? No, right? There is some reasonableness to informed consent. If you say this could kill you, right, I'm going to freeze the skin tag off, but also in the informed consent, death may occur. Like, I have over-exaggerated the risk, right? The reason I'm going to put death on that consent form for cryoablation of a skin tag is because I don't want to do it. I'm now trying to provide every reason for that, anxious patient to get out of it. I'm not doing it because there's a reasonable risk of death, right? And so informed consent is reasonable risk. You as a professional have to decide what is reasonable or not. Blood transfusion, risk of death?
1 to 3%, right? 1 to 3%. If I'm giving you a blood transfusion, that there's a risk of death. Is it going to be related to the blood transfusion itself? Probably not. It might be because you needed the blood transfusion. Much higher likelihood than that. But 1 to 3% chance of a risk of death presents itself with a necessary blood transfusion, okay? Right, so there are certain times where when we're doing a procedure for you, something that is out of the norm, that we need to make sure that we talk about what am I doing for you, what is the expected benefit of it, and then deal with the likely risks that are going to occur in that setting, okay? And then what are the consequences? What are they going to experience in the permanent outcome? Hey, you had frostbite, we're going to watch your fingers, and then I'm going to start amputating them. Well, what are my choices? Well, we can let them go to dry gangrene and they're just going to fall off. Or I can make it look prettier, right? If they just fall off, I'm still going to have to go back and revise the tips on your fingers to make them functional fingertips anyways, right? Because it's just not going to heal up the way that you want it to. You're going to have a little bony nub sticking out. You can color it, you can do whatever, but it's going to be gross. You're going to wish that it was amputated. Okay. You're going to deal with phantom pain and you're going to deal with other components. We're going to have to see you back on occasion to make sure that everything else is going well. You're going to require neurology, you're going to require other consultant services, right? So benefit, risk, and then the outcomes component of that. Those are all of the components of informed consent. When a patient says that they refuse care that is reasonable, they decline care, they refuse care, they don't have to endorse a form to show that they refuse. If they're presented with, and we'll show you the form at the end of this class, if they decide that they refuse the procedure, they don't have to sign anything to refuse. It's the presence of a signature on a consent form that consents to care. Now, what if they change their mind after they've consented? So my 18-year-old daughter now has decided to go ahead with this silly laparoscopic appendectomy, and if she's being wheeled back to the OR, sits up on the table and says, I changed my mind. We got a signed consent form. We don't have there's no refusal form. What do we do now? Who's on the let's do it, hell or high water? We're doing it anyways. Boom. Yeah. No, terrible choice. Anyways, right? What about downrange though? Ooh, different story. We're no longer in the state. We're in the federal system. What's that? Does it matter? Anyone think that whether it matters? It's a great question, right? Because almost all of the military malpractice considerations for service members involve that kind of scenario question. It's mostly with the Navy more so than any other service, because once you're afloat, like they're not turning to port if they can fix it on the ship, and your appendix is coming out one way or the other, right? And the rest of us, there's generally some time to get to that decision. The Air Force is great because they're like, oh, we'll just fly back to the States and you'll figure it out when you get there. If that patient decides at the onset of the procedure, before it is medically dangerous to discontinue the procedure, that they want to change their mind, they have that authority to informed refusal all the way up into the point where the authority now rests on you as the medical decision maker because the patient is incapacitated, right? So if the patient is awake and alert through the entire procedure, they have a right to refusal throughout the procedure. But once they are under your care, they have given care to you. Now you are responsible for executing the plan of care that you worked out with the patient and for which they consented. So while they're still awake and alert, they can say no. As soon as they're under, which gets us to the case that hopefully you guys reviewed, but you probably didn't, and we'll talk about that when we get to Shelley versus Davidson, about what happens when somebody is under and we need to expand their care and what determines necessity, right? So there's two concepts, capacity. Capacity is a medical professional's decision. Do you have capacity? So, turns out that Colonel Douglas, in about 2 minutes. Let's talk about capacity real quick. Turns out Colonel Douglas is a terrible alcoholic. blood alcohol content for me to function every day has to be 0.12 or better, right? If I'm below that, then I start getting tremulous and really going south. When I'm in the ER and I need my scalp stapled up because it's open and it's bleeding, and the way that you fix that is by closing the wound, and it needs to be washed out, can I consent, because my blood alcohol content is 0.2, can I consent to you performing that function? I'm not bleeding so much that it's an emergency. You're not watching my hematocrit drop with every tick of the clock, right? It's a slow oozing bleed that would get better if somebody would just fix the scalp laceration. But I'm drunk, right? Legally, in the state of Texas, I'm like 2.5 times drunk. Can I consent to you stapling up my scalp? Anyone say no? You don't say, you changed your mind? You changed from no to yes because of the way I asked it? I like that. Anyone say yes? Anyone give a hard yes? Yes, I can consent to that because I live my life like I want to. American dream, Bush light. Okay. No? Not quite sure, right? So, in fact, last year I was faced with exactly this dilemma that the chief resident in the emergency department at BAMC was like, you can't perform any procedures on this individual until they sober up. The reality of it is that their spouse, who was on the phone 2 hours away in Victoria and didn't get trauma moved with the patient, acknowledged fully that their SNAP benefit goes towards buying the food that they need, and then their Social Security goes towards buying alcohol so they can enjoy life and they live at their mother's house. In that setting, you're like, okay, well, this individual, are they reasonable to understand and able to repeat back to me what I'm about to do to the individual? Do they want me to perform this thing, and do they understand the consequences of saying no and saying yes? Simple question and answer. Chief resident of the emergency room is raising it up to the staff in the emergency department, who is having difficulty with us proposing this question, and the trauma service is raising it to the chief surgeon at BAMC to say, well, because this is a trauma admission that was flown as a trauma patient from being hit by a car 2 hours away, this is a trauma call, not an emergency department call, right? And the end point is, capacity clearly exists for that patient. They understand why you would want to staple their scalp. You know what they don't like doing? Taking blood out of their eyebrow because it's running into their eye, because it's continuing to ooze from underneath the 4x4 gauze that is taped to their head by the emergency department when they stuck them in the emergency room, right? Because that's the best that they can get to. We're not going to go extravagant and put a bunch of quick clot gauze into it and then expect them to manage that either. The fix to this is something simple, but it's a procedure, right? And they have a right to refuse, and they have a right to consent. And what we just have to understand is, before we go getting hospital lawyers involved over like 60 cents worth of staples, is that, yeah, we should probably make sure that we're reasonably assured in my note that's going to be co-signed by staff that says, no, this individual is capable of deciding what's in their best interest. From a competence standpoint, though, that's where we're getting a lawyer involved to make an actual case for either a judicious authority or the medical director of your MTF can act in that capacity with competent legal advice, right? Generally adjudged by a court, but in the military system, competence can also be, for emergent cases, can be decided within the facility itself. So we've got a couple of different ways to go there. And again, there's asterisks on all things, but let's go ahead and take a 10-minute break, and then we'll come back and we'll hit the very quick decisions and have you guys look at what system we use to get to consent before we kick you out of here, okay? This is a slide, and there are many slides that look like this. I want you to appreciate that in informed decision making, there is a wheel of trust. No, I have no idea. And I don't like this as a physician has a duty to disclose. We all have a duty to disclose multiple elements of these things, and I beat these to death before we went to our break. legally, we evaluate informed consent against three components. The reasonable physician or reasonable provider standard is what it's now referred to as. Would somebody else tell you that you are going to die because you got liquid nitrogen on a skin tag, right? No. If the dermatologist, as the expert in providing skin care, doesn't have it in their consent form, it's reasonable for you to use it. And I tell you this because as you're building your own library or catalog of consent for procedures that you do, for things like toenails, minor skin procedures and other things, find the people who do them regularly, generally dermatology, and use their information. Objective materiality, the probability of the risk occurring, right? So if the risk is a known risk and it's a severe risk, you always have to state it. If the risk is potentially going to occur and it's not a severe risk, right? So I'm giving you doxycycline, and the risk of doxycycline in the sun is pain, redness, whatever else. First, I'm not doing a consent form to prescribe you doxycycline, but I do have a responsibility of telling you what the potential outcomes of using doxycycline and being out in the sun is going to be, right? Voluntariness. So if an individual is incarcerated, if an individual is in the service, they have a limited or reduced capacity for voluntariness. If they are part of a study, so they are involved in a research where they gave consent to the research and gave consent to the idea that they wouldn't know the outcome or the intervention or the control, and they don't know which group that they are in, the initial consent provides the voluntariness component for you to engage in that until it shows evidence of harm, right? "16 years old in the state of Texas, and you've had a kid. You're considered a mature minor. You're allowed to make decisions of your own accord for your own health care. Tennessee, and you are 16 and you are married. Your parents are no longer allowed to make decisions for you, even if you're on their insurance. If public policy allows, so your state authority or federal policy allows a child to make a decision in their own interest, then they are allowed to do so, and they are expected to receive the same informed consent. Do we think this generally applies to kids under the age of about 12? Not usually, right? There generally must be an informed decision maker. But in cases where there is no guardian, there are no parents, the state will generally appoint somebody to make decisions for that individual, right? There are some exceptions to informed consent. Patient waiver, talked about that with research, right? So if I agree that I'm going to be in a blinded study, if I know which arm I am in, treatment or non-treatment, in treatment or placebo group, I violate the conditions of the study, right? I can't receive truly informed consent. In an emergency situation where I am saving your life by stabilizing your vital signs and restoring some basic cognition, I don't need to give you informed consent. If it's ordered by a court, well, what are some examples of when the court orders somebody into treatment? Right? That's your psychiatry class for the most part, right? Suicidality, homicidal behavior, thoughts, or other actions that are not generalities, they're specific, right? They have a list, they have a manifesto. Treatment required by law. So in situations of public health, and I'm not talking about the COVID public health fiasco, but let's talk about a truly serious disease, tuberculosis. Can the state confine somebody with tuberculosis and mandate them into treatment? They can. It can order them into treatment. Why? Because an individual having that disease represents a credible public health threat to other individuals. And it can be basically secluded from society until such time as they begin and demonstrate evidence of treatment for that condition, right? Treatment required by law and treatment permitted by law also gets into two different factors. So in certain states, there is what's called a mandatory report rule. And federally, there's a few mandatory report rules. So if somebody comes into your aid station or they come into your clinic and they have been shot, and it's clear that they've been shot, their patient history and their physical evidence suggests that yes, in fact, they were shot. Why? Because they told you they were shot and they got a bullet hole in them. In that situation, you are required by all 50 states and by the federal government to report to authorities that an individual arrived with a gunshot wound or what you suspect to be a gunshot wound. That's required by law. If you neglect to report that, right, you are potentially obscuring evidence of a crime, right? This is now not in the tort category. This is now purely in the crime category of things. But required by law, if you're initiating treatment for somebody who is evidence of a clear crime, a clear assault, battery, deadly weapon, something else like that that would be otherwise considered a felony, whether you know the list of felonies or not, you would be considered a mandatory reporter. Now, in the setting of behavioral health care mostly, and in some cases where you are allowed to have provider discretion. So, reaching back a couple of years ago, when we talk about abortion care. So, certain states might forbid the practice of abortion, and other states might allow conduct of abortions, but where the state was permissive for abortions, a provider could decide or could not decide to engage in either a chemical or a medical, mechanical abortion for an individual. Right, and it was allowed by that provider without any discussion or discretion by the state. Right, so there's some examples where informed consent exceptions can potentially occur that we don't have to go through all of the components of the informed consent. But I would tell you that if you're performing an abortion and you're not giving the patient full informed consent, you've missed the entire point of why you say you need to be giving an abortion anyways, right? In all circumstances where you as a provider are engaging in an action, you should be providing your patient the fullest detail of why you're doing it, unless you're conducting research. Right? Another example of treatment permitted by law would also be where you're not required to report to public health a certain condition unless it meets a certain category, but you're providing that information. So violating protected health information norms generally allowed within your profession, and you would generally know what those things are. Or we're talking about features of public health. Service member exceptions, we hit the asterisk on those. Immunizations, that's probably the biggest one. Isolation and quarantine, right? So if you go into a place that has a tuberculosis thing and you guys experience an outbreak, we could potentially keep a ship at anchor instead of letting it dock until we can affirm whether or not we have engaged in treatment for everybody that's on that ship. That sounds terrible. To me, that actually sounds like the worst thing that you could possibly do. Hey, the shore is right there. If I just jump off the ship, well, you'll probably die there. There are also sharks, because I believe that the water is full of sharks, because I'm in the Army, right? And then you will die of tuberculosis on shore. But you've brought the pestilence to the shore, and so that's what we're trying to prevent, right? So isolation and quarantine, we don't have to tell you all of the reasons why we're doing it. We just have to give you a reasonable order, right? All these things change a civil matter, right? False imprisonment, medical assault, battery, and malpractice into a criminal matter, which makes it the authority of the command to make that decision on your behalf, right? Talk about optional form 522 is the form that we document informed consents for procedures on. I'll give you an example of that in a minute. And in the state of Texas, there are specific rules for specific procedures. Basically, anything that receives a CPT code, so it receives a specific coding in the note for you conducting that additional procedural component, where you will be required to demonstrate how you achieved consent. Did anyone read Davidson versus Shirley? No? Everyone? What? Somebody did? Gold star. Right? What happened with Davidson and Shirley? What actually happened? You willing? Yeah. You're the only one who read it. Everyone else here is like impressed.
I read it after you talked.
Okay.
But There was a 36-year-old woman who was pregnant. Her medical team decided that with her age, with the baby's position, and with the size of the baby, that a C-section would be the best option. Her and her husband both agreed, but once the operation occurred, not only did she have significant uterine bleeding, but the surgeons noticed a mass on one of her ovaries. And rather than going and asking the husband for consent to remove it, they just took it out anyways, which caused extra bleeding. So she was now hemorrhaging enough that the medical team decided to do a full hysterectomy instead of the tubal ligation that she had opted for. So both her and her husband decided to pursue legal action against the medical team. And then I remember the first attempt was pretty much a bust. They decided that they didn't really have a case, but then they revisited it. I don't remember.
Okay, yeah, so in 1975, you imagine the rules were a little bit different then in terms of husband as observer for a C-section versus now, right? When you guys go in and do your labor and delivery in phase 2, you're going to find that the husbands are there, gowned up and masked up, probably more protected than you are if you're helping assist with C-sections, right? But in 1975, the husband was in the Hall of Shame smoking cigarettes inside the hospital, pacing and waiting for, good news, it's a son, right? Just like the TV shows from the 1970s all showed. The consent that was performed for Annelle Davidson, was for a C-section and tubal ligation and any necessary therapeutic procedures. Any necessary therapeutic procedures. Why? Because we are cutting open your abdomen for a C-section. It's a low transverse laparotomy into a section of anatomy. So any therapeutic procedures that may be necessary would be anything that the professional decides would be required. And because she's not in a position to observe or make determinations and doesn't carry the professional authority to do so anyways, it's relegated back to the physician team. Second child, she's a nurse, so she is aware, at least from a professional terminology standpoint, of what she should be consenting to, because she's been a witness to at least one other consent before. And frankly, the majority of the witnesses for your consents are nurses and have always been nurses to consent forms, right? So has a valid consent to do a C-section, to do a tubal ligation, and any necessary therapeutic procedures. What it did not say is any life-saving procedures, it said any necessary therapeutic procedures, right? So the district court upheld summary judgment in support of the defense of Dr. Shirley and Shirley's medical team that was sued by Ms. Davidson for the emotional distress of a unplanned hysterectomy when she wanted a tubal ligation, right? That's what she sued for, was the unplanned element of this, not actually the loss of her uterus, but the lack of control that she felt as a result of it, right? And was seeking damages from that, not because she wanted to have more kids necessarily, although that may be a component of it. That's not brought up in the case law. But what's brought up in the case law for this consideration is, did the physician have a right to go from closing the uterus to realizing that there was an adnexal, an ovarian mass, consulting with the colleague in the room and saying, that appears to be, I agree with you, that is a tumor. How do you know that it's a tumor, right? So what you see is a vascular embedding that is occurring. So it's a prominent feature of that ovary. There's a whole network of blood vessels that are now growing into it, right? It doesn't look like a normal, like the ovaries are generally very small when you're doing that C-section. They're kind of out of the way, right? They haven't been very active in several months, right? Generally small anatomy, but now you get to see something that's overgrown and it's got this vascular bed that is just growing through it. Would it have been appropriate for that physician to have attempted first tubal ligation through that one potentially tumorous vascular bed? That's always a bad choice, right? Hematogenous spread is the most common way for spreading cancer, right? But am I going to do that tubal ligation potentially across that vascular structure. That's a bad choice, right? That's opening me up for future litigation when it turns out that that is in fact ovarian cancer, right? So that's not really an option for the physician. What if he closes the abdomen? What if he doesn't perform the tubal ligation? Look, we got in there, I realized I couldn't perform it, but he closes the abdomen while he was in there, knowing that the patient has a suspicious mass. And he has the consent already present to perform other therapeutic measures, right? Not life-saving. This isn't life-saving right now. It's not immediate to the condition, but it's therapeutic. What am I going to have to do to take out an ovarian mass? I'm going to have to cut the abdomen back open again, right? So I'm going to have to go through scar tissue, and it may be potentially more difficult for me to remove the mass on the second operation because it may have grown, it may have shifted, it may have become adherent because the next stage of growth beyond the neovascularization is generally adherence to other outlining structures. So it may have gotten bigger, which is consequential if you're a physician that noticed it the first time, right? So what does an obstetrician, what does a gynecologist do in that setting? They realize that their consent form gives them the presence of professional objectivity to make a decision. And so what decision did they make? They took the ovarian mass. Where does the blood flow to the ovaries come from? Branches off of the uterine arteries, right? They branch outward and feed that. So the growth into that space is coming out of the uterus anyways. So I cut these vessels and they retract into the body of the uterus. Well, that seems terrible, right? Because now how do you clamp a uterus? Manual pressure, right? Quick clot gauze, it was still about 40 years away from being invented. Okay? 30 years away from being invented at that point, right? So you're going to put manual pressure, you're going to put some lap pads into that space, and you're going to push down on it, you're going to hold pressure on it, and you're going to hope that that does it. Then you're going to apply a few other chemical agents on or about it to try to get it. You're going to put some Surgicel, some cellulose in that space to try to get those things to clot off. And when they don't, because the arterial bed has retracted into the uterine space, then what is a gynecologist left with? Hysterectomy, right? We're taking the organ, and we're cutting off the vessel at its base, and now there's no more risk of bleeding. Does the physician have consent for the patient to do this? That was the question that was brought forward as the basis of a civil suit against Dr. Shirley by the patient. I am owed emotional damages for the loss of my uterus because I don't believe he had the right to take it. The expert witness for Davidson, who was brought into court for this case, agreed that in a similar situation, he would have done the exact same thing. That's a terrible expert witness if you're a plaintiff. Go get somebody that's going to tell your story and make it real, right? But in 1975, or 1976, when this case was tried, that's exactly what ended up happening, is that the physician who was brought in to make the case for the patient as an expert witness was like, no, under these circumstances, the only option that was available to Dr. Shirley was, in fact, to perform the hysterectomy. He could not close the abdomen over a suspected tumor when he's going to document that he suspects a tumor that's there. That's creating a future risk to the patient, a known harm, and he's responsible. That's malpractice, right? What an untenable situation to be in. Go ahead.
Is it still malpractice even though the patient has multiple risk factors for having a tumor hemorrhage? Like AGA, large baby, fibroids?
Is it malpractice to close?
Could it be argued that you could delay the tumor removal because of the fact that the patient already had so many risk factors for having a bad outcome?
Well, you have to that's where you get to the professional side. If you're talking about outcomes, professionally, what is the outcome of greatest risk to the patient? A fibroid, a uterine fibroid, or any of those other factors that are there, those aren't exceptional risks. Why? Because we can now do laparoscopic procedures to remove fibroids, right? So fibroid in itself, advanced maternal age is no longer an issue because the baby has been delivered, right? So in terms of the existence of bleeding, so peripartum bleeding is the factor that is of the only consequential concern for a life-saving measure itself. The practice of closing an abdomen with a tumor is potentially a death sentence for a patient, right? If I'm in a patient's abdomen and they have a tumorous mass, regardless of where it is in the abdomen, and I close the abdomen, that is a clinical decision to not treat, right? Which is avoiding my responsibility if I had the surgical authority to be there, and then I have a surgical authority to exercise professional judgment, right? So that's the part where if her claim was, I was expecting to have a whole family of 7 or 8 more kids, and this was unclear to me in the consent that this included this potential or this other component. Those were brought up in trial, and she acknowledged that she was aware that this was always potentially a risk of having a C-section. And it's documented as one of the top 3 items in receiving a C-section is that it may require a hysterectomy if we're unable to stop the bleeding. So it was well established that this was a potential consequence. But it didn't occur because of the C-section, it occurred because of the next thing, right? So from a standpoint of, she makes some great arguments about, how much scope of authority did I give away, but to the court and to the Court of Appeals, the Middle Georgia Court of Appeals, in all of the settings here for what she was complaining about, there was no validity to the complaint. She was aware of all of the risks that were there. And why this is brought up from a 1975 component of case law is, if it's not an incentive for us as practitioners to widely open any necessary therapeutic procedures and consent, it actually forces us to close the gap of defining what therapeutic procedures would be considered consequential, so that the patient understands then that if I observe a tumor, a mass, or other thing while I'm present there, that I may take that, if I believe it to be concerning, for pathologic reasons, right? And we may conduct a hysterectomy because of the direct consequences or indirect consequences of doing them, so that those are more fully explained, but it probably wouldn't have changed the outcome. Now, if she had had a vaginal delivery, difficult vaginal delivery, and delivered the child, and the child was born healthy and other things, she probably still would have moved, because of the nature of the ovarian mass, into a hysterectomy within 1 to 2 years later, which is another consequence of that piece, is that they were probably going to remove the ovary and probably follow the bloodstream back to the uterus anyways. And if it bled a lot then, it was probably going to bleed a lot when we removed it later, and it was larger and more vascular, right? So from that standpoint, removal of the ovary was always going to be a consequence of the finding, and hysterectomy was going to likely be an outcome of it. It's just the timing of all of the things occurring in the same space, right? So it's important for you guys to make sure that when you're doing informed consent, that you're really actually providing the information that you should be. And that you're not trying to create this broad exception for any liability whatsoever. Be focal on what you're doing. We're going to hop into active consent here real quick, and then we'll get you out of here. All right. So when you guys get your DHA accounts, because you're all going to graduate, right? Yes, please, God. And you're all going to go to phase 2. When you get your DHA account at your respective facility, the screen's going to look something like this, right? This is my BAMC account through ADHE. But you're going to have a whole bunch of things here. The one that you're going to love and hate is going to be this MHS Genesis one. The one that you should spend way more time in because you love radiology is the AGFA Healthcare Image Viewer, and that's where you can look at all of the images that are there. But most of your primary care colleagues are just going to read the radiology results that are in the MHS Genesis and move on from there. But I encourage you to never forget that this one's important, because sometimes the radiologist doesn't know left from right. The one we're looking at right now is IMED consent, right? And so this is a tool that generates that optional form 522, but it uses a bank of already existing consents that have been built up by hospitals and departments for a long, long, long time to produce the final form. So what I pulled up in my search
and I didn't put a patient in here so that it's a little bit easier for you, but I used the search term toenail, right? So when I search for toenail across the broad DHA database of consents that are here, it comes up with removal of tail of nail and or matrix or toe phalangoectomy. Let's make sure first that we're making the right call, right? Now, if I'm really bad at this, see at the bottom here where it selects both consents, right? I just click the possible box. The other one that doesn't have a box clicked against it is the procedure of interest. Okay. Start. The patient data blank, and this is for a print-only signature. Who's the performing provider? Who's the counseling provider, right? So who's going to actually tell the patient what's going on? It's usually the same person, but it's not always the same person. You guys as PA students may be the performing provider, but there must always be a licensed credentialed provider in that space. You may be the counseling provider telling the patient what you're about to do, and there must always be a licensed credentialed provider in that space as well. Will a second provider be signing this document? For you guys, that answer is yes. Right, great toe, right, big toe. Either one of those are acceptable. Do not call it the first digit on the right foot, right? Common, simple, 4th grade language for informed consent. Select images for viewing and imports to consent document. If I had a picture of your big toe, question 1, why do I have a picture of your big toe? Question 2, like, do I need to put that in the informed consent? It may be for things like a tattoo removal, where I want this tattoo removed, but I want that one to remain intact. Where it's important in the informed consent that I'm showing you exactly which, nipple I want you to take off and which one to leave, right? Because why was I born with the 3rd nipple, right? It can happen. Supernumerary, it's one of the best words ever. We describe that for staff officers and Army battalions. Any exceptions to treatment or surgery? None. Patient signing for his or herself? Yes. Now here is the pre-formatted language that you would otherwise need to put into this thing. Possible phalangoectomy. I love this. So tail and matrix removal, toenail and matrix removal is all of these words. Possible phalangoectomy. This procedure involves the removal of bone from your toe. Okay, right? So you see that some of them can be very descriptive because there's a whole lot of ways of taking a toenail off of somebody, and you can choose to temporarily do it or you can permanently ablate the nail. There's a lot that goes on with that procedure. Removing the bone from your toe is just removing the bone from your toe. There's a whole lot of discretion about it, right? Treatment, procedure, likelihood of these benefits. We're talking about the benefits. Known risks. I don't see death in anything here. Nail and or matrix removal. Bleeding. That's a good one. Changes in the nails. Yes, that's probably true. Pain, numbness, weakness, scarring. May change, may not cure, may not get better. Wound infection, poor healing, reopening of incision. There's no mention of death from a toenail removal. That would be impressive. You would have to be tugging really hard. Phalangoectomy, removing a bone from your toe, includes floppy toe as a potential risk, right? So this generates all these things. We're talking about consent for blood. If I'm consenting you for blood with a toenail, I'm probably digging too deep, right? But you could leave that on there. You generate the document and it goes to sure you do. It goes to an optional form 522 when it works. But the optional form gives you the actual form for somebody to sign and for you to use as the counseling document. If you're going to the OR in pre-anesthesia for every patient that's about to get a surgery, there will be an IMED consent performed and it will be printed out at the nursing station and it will be put into the counseling form
you go in with a skin marker and you mark the location where the surgery is going to be performed, and then you endorse the optional form 522 and then the actual pre-procedural checklist, right? So there's going to be 2 or 3 documents in one patient for you to sign to indicate where you're going to get that informed consent. Can anyone think of a procedure that they might want to see an informed consent on? Anyone?
Craniofacial resection.
Bipartition monoblock, orbital box, osteotomy, excision of glabellar mass. So there's a whole lot of specific ones that are there. If I just went. Chemical peel? No? Zygomal reconstruction, right? You're probably bringing too many options.
Sir, is this also a source for just general patient education as well?
So not as good for patient education, right? So there's a patient education component that's already contained within MHS Genesis that has already pre-vetted, so pre-AI and then now secondarily updated by AI. There's patient education within MHS Genesis for the diagnostic conditions that you identify. And this is the discussion of what you're going to do in broad terms. The specifics of patient care are secondary to the consent itself. And there's generally a separate component for patient care, patient outcomes, wound management, and other functions. There is a whole lot to look through here when you are at phase 2 and you're getting into the system. There's a whole lot to look through here, but there's a lot that's applicable into the outpatient setting because you're going to be the principal providers of procedural care within your care settings. If a medic is performing, or a technician or a corpsman is performing procedures for you, they need to become aware of use of the consent form, specifically because when a shoulder injection or a knee injection or a ring block gets infected and that now needs to go to orthopedics, what you want is a clear evidence that the patient was aware of the risk and that you had a procedure in place that shows your authority was extended to the individual who actually did it, right? Now, let's talk about when you're deployed very quickly. Is anyone going to print off 8,522 forms when you deploy? No. And our EMR system hasn't really improved in our deployed setting since 2004, and it doesn't really work or connect to anything either. When you are documenting in the deployed setting to make sure that you're demonstrating informed consent, procedure, your expected outcome, the benefit, the risk, and how the patient demonstrated understanding and agreement, okay? They don't need to sign the SF-600 necessarily below your signature on their medical record. But there needs to be some evidence that you describe. Again, it's the provider's responsibility to describe informed consent and patient agreement to treatment. Otherwise, in the deployed environment, the only time you're not going to care about that is when they're screaming in pain and you're doing everything necessary to gain control of their hemodynamic state and their pain so you can make better, adequate, and informed decisions, okay? Once you've got those in control, then it's reasonable to actually start talking about medical decision-making with the patient's consent, right? Which includes a little bit of that right to refusal if they're wearing the uniform, but not as much as it would be if you were in private practice. And for those of you that are going to enter private practice from the Guard and the Reserve standpoint, appreciate that you practice defensive medicine and not offensive medicine by being a good communicator and bringing your patient along in the process so they understand what they're doing, okay? Guys, I took a little bit longer than I always anticipate. Sorry for the second round. I owe you on the third round. And I got you for a whole bunch next week, so I can definitely make up for that one. If you have other questions about this or just want to see this system later on, we can do this next week. I know you need to get out of here because there's more important things coming for the end of the week. So appreciate your time. Any questions? Excelsior.
Thank you, sir.